Welcome back to Court TV Live. I'm Ashley Wilcott with you this afternoon. Thank you for joining us. We have breaking news. We've all been on pins and needles as this jury in Minnesota versus Kimberly Potter has been deliberating. Today is day 4 of deliberations, and you can see on the clock that we keep, they have been deliberating for a little more than 28 hours. But we have been told that a verdict has been reached. And in fact, the official Minnesota judicial website states that a trial outcome has been reached. As soon as they return to court, we will take you live there. We're expecting that that will be announced this hour. In the meantime, and the jury has really shown signs of being deadlocked on a verdict because they basically said that. At one point, remember, they did ask Judge Chu about what to do if they didn't reach a consensus.
The first question is, if the jury cannot reach consensus, what is the guidance around how long and what steps should be taken? And the answer is, I'm going to reread to you an instruction that I previously gave you. You should discuss the case with one another and deliberate with a view toward reaching agreement if you can do so without violating your individual judgment. You should decide the case for yourself, but only after you have discussed the case with your fellow jurors and have carefully considered their views. You should not hesitate to re-examine your views and change your opinion if you become convinced they are erroneous, but you should not surrender your honest opinion simply because other jurors disagree or merely to reach a verdict.
This jury has had to decide whether or not Kim Potter was criminally reckless and or negligent in her shooting of Daunte Wright. Until we get that verdict, we know it's in. Until we get that, we're going to continue our deep dive into the most impactful testimony in this case that this jury had before them to consider. One of the most important witnesses to testify in the defense's case was former Brooklyn Center Police Chief Tim Gannon. This is Kim Potter's former boss. He resigned 2 days after the incident. He told this jury that when he reviewed the body cam video from the incident, he saw no violation of police policy. Take a look.
What about her volunteer work? Are you familiar with that?
I am familiar with that. Early on in her career, she did volunteer and began working for LIMA.
What's that?
LIMA is a Law Enforcement Memorial Association.
Slow down just a little bit.
Sure. It's a Law Enforcement Memorial Association, and basically what they do is they lend support to fallen officers and their families. They are at funerals. They also very extensively help the families go through this process, which can be very traumatic and tragic.
And that would be law enforcement that was killed on duty, correct?
In the line of duty, yes.
In the line of duty. Was she also on a DART committee? Is that?
Sure. DART is our domestic abuse response team. So one of the initiatives that I had brought forward with the help of my command staff was a follow-up for we'd have domestic abuse survivors, and a lot of times they wouldn't get all the resources they need at the original time of call. And what the DART team would do is they'd follow up afterwards, even the next day, to make sure that that survivor has all the benefits that they need, that they're talking to an advocate, that if they have any questions about the upcoming trial, they supply them with that. So a select group of officers would do that.
And she was one of them?
She was one of the original members.
Also, was she an FTO when you worked there?
She was a field training officer for a long time. One of the things related to that is we don't get very many senior officers to do the field training officer program because they're basically they've had a lot. They've done a lot over their careers, and they leave that up to other officers. We have a few senior officers that still do that, and she was one of them.
And did you continue to be the chief of Brooklyn Center Police Department up until April of this year?
I was promoted to the chief position in September of 2015, and I served in that position until April of this year.
Yeah, and what happened in April of this year?
Officer Potter, or Kim Potter, was involved in the shooting incident, And the aftermath of that related to the political pressures within the city. I was no longer allowed to stay as the chief of police.
And was that because you would not terminate her until she had a due process hearing? Objection,
The objection is overruled on that ground. You may answer.
I believe one of the reasons that I was required or requested to leave the agency was because I would not immediately fire Kim Potter.
Did Kim Potter leave voluntarily after that? Quit her job?
She did resign her position to me while I was still the chief.
Okay. Let's go to April 11th of this year. You were still chief at that time,
I was.
and that was the day that a critical incident happened, is that correct?
Correct.
Did you weren't at the critical incident at any time, were you?
I was off duty at the time.
And however, you did look at PWC body-worn cameras afterwards, is that correct?
I did.
The objection is overruled.
I'm trying to lead you into that, sir. Did you observe body-worn cameras after the incident?
Yes, I did.
And what body-worn cameras, if any, did you observe?
So on the night of the incident, I had been called in, and I was at the police station, triaging the situation, working through the incident. I was advised by a BCA agent to take a look at the body-worn camera footage from Kim Potter's camera, and that's what I did.
Later on, at some time later, did you look at more body-worn camera?
I looked at one other camera angle much later, and that was the squad cameras. So within the police department, our officers carry and have on their person a body-worn camera, but also early on in the process, we had mounted squad cameras that can watch and can monitor outside of the car directly.
So you're able to see inside the car before the stop, is that right?
Yes,
And you saw the stop, and you saw the arrest, and you saw the aftermath, correct?
I did.
And after viewing all of those incidents and the body-worn cameras, did you see anything based on your knowledge and experience that her conduct was consistent with her training at the Brooklyn Center Police Department?
When I viewed both camera angles and had all the data in front of me, I saw no violation
No violation of what?
of policy, procedure, or law.
And the policy and procedure at Brooklyn Center Police Department, to your knowledge, since you're the chief, followed the law of use of force, is that right?
Yes, it does.
Let's bring in my guest for this hour. Still with us in Minneapolis, we have attorney and former radio host Roshini Rajkumar. Also joining us now in Wisconsin, criminal defense attorney John Birdsall. John, let me start with you first. As a criminal defense attorney, what do you think this verdict is?
Well, it's kind of a tough call in a number of ways. First of all, the environment after the George Floyd case, and this follows, shortly on the heels, it has to be pro-prosecution. On the other hand, if you read the statute and with what Potter is charged with, they have to find that she consciously took a chance for causing death. And the whole, it was a mistake defense might sound, silly to some ears, but I think it might hold some water. And if I had to call it, I would probably say this is going to be a not guilty verdict.
All right, and we are going to bring you the outcome as soon as it's announced. Roshini, we're going to get to you on the other side. We want to take the opportunity to squeeze in a break. We'll be back here with the live continuing coverage of the verdict on Court TV. The verdict is in the case of Minnesota versus Kimberly Potter. As soon as court goes back into that courtroom, we will take you there live. We have a court TV team who is there in the courthouse, so we will bring that to you as soon as there's any movement in that courtroom. Still with us to talk about this, attorney, former radio host Raj Kumar, sorry about that, Rashini, as well as criminal defense attorney John Birdsall. Let's start with you, Rashini, if we could. You had said earlier your prediction is either an acquittal or second-degree manslaughter. Is that still where you are thinking after 28 hours of deliberation?
It is still where I'm thinking, Ashley, but while we were in break, I reread the email that went out from the judicial branch. And I mean, I don't want to get too nitpicky about language, but it said an outcome will be read on the record between 1:30 and 2. So the word outcome instead of verdict was in that memo from the judicial branch. So I just say that to you here. I have always thought if you're going to charge this case, and there was also reason not to charge out this case, it was second-degree manslaughter. So after 28 plus hours of deliberation, if the jury comes up with an acquittal, I think that is a fine result. It makes sense on what we saw in court. And if they come up with a second-degree guilty verdict on that second-degree manslaughter charge, that also seems like a result that makes sense that you can hang somewhere. But as was pointed out earlier before we went to break, there's a lot to be said about this mistake defense, and a lot of people could easily buy that on the jury. That would be very believable for the jury to really read into the mistake, see the emotion that came from Kim Potter, and come up with an acquittal here.
And that was certainly the defense's theme in closing argument. They said it was a mistake. It was a mistake, not a crime, but a mistake. John, let me get your opinion on the first-degree manslaughter versus the second-degree manslaughter. We know that initially Kimberly Potter was charged with the second degree, and then after that, after other events transpired, the first-degree manslaughter charge was added. Do you feel like that was overcharging?
I do. I think, as was just pointed out, I think this easily could have been a case that wasn't charged at all. But the fact that it was, and then they kind of pile on, that is very routine in criminal cases, certainly in Wisconsin where I practice, but all across the country. And the point is to try and make the life of the defendant so uncomfortable that they reach out and try and make a plea offer. But you know, if they really thought that first degree was the appropriate original charge, then they should have just done that in the first place.
All right, what is this jury going to do? We are waiting to find out. We are expecting the verdict to come in anytime. We're going to take a short break, and we'll be back right on the other side. Breaking news, the verdict is in. Minnesota versus Kimberly Potter. This jury has been deliberating more than 28 hours. Word has been received. The verdict clock has been stopped. They have a verdict. As soon as they return to the courtroom, Court TV will take you live into the courtroom. In the meantime, we want to take a deep dive and talk about the last witness called by the defense team. Kim Potter herself, she did take the stand in her defense to tell this jury her version of what happened the day that she shot and killed 20-year-old Daunte Wright. And she got very emotional during her direct examination as she described the fear she saw in Officer Johnson's eyes as he leaned into the vehicle trying to stop Wright from taking off in the car. And then on cross-examination, Potter broke down further as she apologized for what happened, saying she didn't want to hurt anyone. We can see there on the screen how she was acting during this emotional testimony. Still with us to discuss, attorney Rashini Rajkumar, as well as John Birdsall, criminal defense attorney. First, John, is this emotion something that the jury believed in this case, in your opinion?
Well, if the jury believed it, that's one thing. I tend to view police, testimony about excusing their own conduct very skeptically. But that said, I thought that she came off as pretty credible and pretty sincere. But I only say that when you combine the video from her body cam and the crying at the scene, which couldn't have been prepared, which couldn't be faked. And so I think the jury, if they look at those two in conjunction, they're going to have a very sympathetic view of her.
All right. Rashini, I have some good information. 15 hours elapsed between the time the jury asked about the consensus and what to do if they couldn't reach one and the amount of time they deliberated to now when they have a verdict. So 15 hours since that question. Do you think it's a hung jury knowing that?
That is so tough, Ashley. I don't think it's a hung jury anymore. I've been on with you all a couple different times this week, and I did predict a possibility of a hung jury, but I've also stuck with that possibly guilty on the second degree. So I just think that they really did try to come to a conclusion and so that this trial doesn't have to be retried. But again, juries are human. I've been wrong before on my guesses with juries, and so we will have to see.
John, what is your thought when you hear 15 hours is how long they deliberated after saying to the judge, what do we do if we can't reach a consensus? And she said, you go back and you keep talking.
You know, that is always a challenge to try and predict these things. And it's virtually impossible. And because we just don't know what they're talking about in the jury room. But the fact that they wanted to see the gun and handle the gun and, they're definitely taking it seriously and they're definitely trying to weigh, whether this is a reasonable mistake. And even though, the mistake isn't an official affirmative defense, I think they're trying to determine if she could have consciously known. If you watch the body cam, the gun is clearly visible, and she drew it with her right hand, not her left. And so a conviction is a very real possibility. But if I had to guess, I'm leaning against a hung jury, and I'm leaning more towards acquittal.
All right, stay with us. We know now that the individuals have assembled in the courtroom. We're going to take a break so that when they go live, we will take you there live. Court TV, your front row seat to justice. Welcome back to Court TV Live. I'm Ashley Wilcott. Thank you for joining us. You've seen the breaking news. A verdict is in Minnesota versus Kimberly Potter. We know everyone is in the courtroom. Going to court, the judge is taking the bench.
Okay, is counsel ready for the jury? All right. Okay, deputy, you may bring the jury in. All right, please be seated. Members of the jury, have you arrived at a verdict? Okay. Will the deputy please retrieve the verdict forms and provide it to me for review? Would Ms. Potter please rise? I'm now going to read your verdicts as it will appear in the permanent court records of Hennepin County. In the matter of State of Minnesota versus Kimberly Potter, court file number 27 CR 217490, we, the jury, on the charge of manslaughter in the first degree while committing a misdemeanor on or about April 11, 2021, in Hennepin County, State of Minnesota, find the defendant guilty. And the verdict was agreed to at the hour of 11:40 a.m. and signed by the jury person on 12/23/21. The verdict on count 2 is we, the jury, on the charge of manslaughter in the second degree, culpable negligence on or about April 11, 2021, in Hennepin County, State of Minnesota, find the defendant guilty. And that verdict was agreed to at 10:30 a.m. on 12/21/21. Members of the jury, is this your true and correct verdict? So say you one, and so say you all.
Yes.
Okay, you may be seated. All right, I am now going to poll the jury. Juror number 2, is this your true and correct verdict?
It is.
Juror number 6, is this your true and correct verdict? Juror number 7, is this your true and correct verdict?
Yes, it is.
Juror number 13, is this your true and correct verdict? Oh, it's juror 11. And juror 17, is this your true and correct verdict?
Yes.
Juror number 19, is this your true and correct verdict?
Yes.
Juror number 21, is this your true and correct verdict?
Yes.
Juror number 22, is this your true and correct verdict?
Yes.
Juror number 26, is this your true and correct verdict?
Yes.
Juror number 40, is this your true and correct verdict?
Yes.
Juror number 48, is this your true and correct verdict?
Yes.
And juror number 55, is this your true and correct verdict?
Yes, it is.
Okay. Members of the jury, when you first came into the courtroom, I told you that jurors are the heroes of our judicial system. Well, the 12 of you are our heroes in this case. You might remember that there was a question on the questionnaire that asked whether you wanted to be on this jury. You were to check yes, no, or maybe. A number of you checked no or not sure, and a few of you checked all three. But when I asked each of you if you would be willing to serve if the party selected you as a juror, you all said yes. You said yes even though we are in a pandemic with Omicron spreading in our community. You said yes even though you had concerns about serving given the nature of the case. You said yes even though you knew you would be sequestered during deliberations and away from your loved ones. And you said yes, even though there was a chance that this case could have lasted past Christmas. You were willing to sacrifice much because you believed in our justice system. And then you went into deliberations, and each of you brought with you your common sense, individual perceptions, and life experiences, and you came to an agreement on the verdicts. You did your duty. I'm so proud of you. You should be proud of yourselves. Without civic-minded citizens like you, our system of justice could not function. Thank you for your service. Thank you for your sacrifices. I wish you all a wonderful holiday season, and may the peace and beauty of the season be yours throughout the year. At this time, I'd like you to go into your waiting courtroom, and I'll be in just a moment. I'd like to thank you personally and to answer any questions that you have, okay? Okay, please be seated. All right, Council, we have to pick a date tentatively for sentencing. So for in custody, we'll be taking Ms. Potter into custody and holding without bail. So what is 3 weeks out? I think we probably want to do a tier 4.
So we will be looking at January 13th or 14th. We can do 11:30 on either day.
For sentencing?
For sentencing.
Your Honor, you want a pre-sentence report?
Yes, I'm having a PSI report done.
We are not available on the 13th. I believe we could do the 14th.
You know, I'm in trial the week after that, and it does seem to be a little accelerated given the seriousness of the decisions you're about to make. So later in January would be our preference. We also would like to talk about the bail issue with you before you decided, before you make a decision to take her in.
All right, I'll hear you out.
Go ahead, Mel.
Well,
You know, I think it'd be easier for the court reporter if you went to the podium.
Well, I'll go after you. We both say a little bit, Judge.
Yes.
well, you know, there hasn't been a motion. I anticipate they would file a motion, but this arguendo, they're going to file a motion to revoke her bail. You know, we will be filing a motion for a dispositional departure on the case. She is amenable to probation. Her remorse and regret for the incident is overwhelming. She's not a danger to the public whatsoever. She has made all her court appearances, including all appearances in the court. It is the Christmas holiday season. She's a devoted Catholic, no less, and there is no point to incarcerate her at this point in time because A, you haven't decided what the sentence is going to be. B, the dispositional departure arguments are quite strong on this case. And C, it's not necessary for the preservation of public safety. So for those reasons, she need not be incarcerated whatsoever pending sentencing. You certainly can do it after sentencing, but this is a rather unique case of someone who has law enforcement experience and was never in trouble in all her life and is 49, which is beyond the age of most defendants that you see. Plus she has deep roots in the community and her family's here, and there's no evidence that she would flee. So we respectfully ask you to change your mind as to whether she needs to be incarcerated right now. I know Mr. Gray has a couple comments too.
Your Honor, her bail right now is $100,000. She's got that posted. She's not going to run. She obviously is not going to commit any more crimes. She's been convicted of an accident. She's been convicted of being reckless. I just would like to be able to, with Paul, file a motion for dispositional departure in this case. I think there's other facts that didn't come to light during the trial that are important also about Kim Potter and about this case. So I respectfully request that you release her on her $100,000 bail, and that'll make it easier to do the pre-sentence report. We'll get people sending letters on her behalf. And I would ask for a sentencing sometime after, if you release her, sometime, I start a trial January 20th. It should be over by February 20th, I hope, sometime in late February. And ask that my gosh, she's got a $100,000 bail up, Judge. But, you know, she's not going to commit another crime. She's not going anywhere. Thank you.
Okay, Mr. Frank.
Thank you, Your Honor. We do request that the defendant be taken into custody. The convictions here are for manslaughter in the first degree, manslaughter in the second degree, based on the death of Daunte Wright, a young man. In other words, it's a case that involves a death. They are very serious charges. It is customary for defendants to be taken into custody upon a guilty verdicts for those level of crimes, and we don't think this case should be any differently. Your Honor, we also have learned that the defendant is not living in the state. I don't know if that was known and provided for in the original conditions of release, but it presents obviously an aggravating factor for allowing her to remain out of custody. So we are requesting that the state remand her into custody and withdraw any bail or conditions of release. Your Honor, we do have the Blakely issue to resolve, and we would be asking some direction from the court on whether we should submit written arguments or proposed findings, or how the court exactly wants to address that. It would be good to have those findings, of course, for the actual sentencing hearing, and we would request a PSI as well.
Judge, may I respond? Just,
Yes.
it's a serious crime, I understand that, but both of those crimes there's no intent, no criminal intent, it's reckless and culpable negligence. Many times in my career, I've had defendants convicted of culpable negligence. I don't think I've ever had a reckless one, but it's an unintentional crime by somebody with a clear record. And we have a strong basis for a dispositional departure. I asked the court to release her on the bail. She surely will reappear.
Okay. The presumptive sentences in this case are commits, and I am going to require that she be taken into custody and held without bail. And I recognize your arguments, Mr. Ng and Mr. Gray, but I cannot treat this case any differently than any other case. So, I think we should probably set briefing deadlines. I know that the defense would like to make a written motion for dispositional departure. And the state has the argument concerning aggravating Blakely factors then that we should be briefing. How much time does the defense need to put in their motion for dispositional departure?
At least 1 month. We're backed up, both of us are backed up on trials right now. I start one on the 20th as well.
Okay.
So at least 1 month from, at the end of January would be preferable.
Okay. Pick a date in January and I'll give the state what they need to respond.
Well, the January 31st then.
January
Yes.
31st, that's a Monday.
Okay. And how long would the state like to respond to the motion, the sentencing motion?
Could we have 2 weeks, Your Honor?
You may, and that date would be, Zach?
February 14th.
Okay. And Mr. Frank, I think that the aggravating factors, we did the Blakely on a unitary basis, so no further evidence would be required, correct?
That's correct, Your Honor.
So could you submit your brief on the aggravating factors? How much time do you need on that?
2 weeks, Your Honor?
Okay. And the defense would need until, okay. And Mr. Kramer, could you tell them what the dates are?
Why don't we do them all on the 31st then? You might as well have an omnibus submission for the defense.
Okay. Do you want to do them simultaneously on the 31st?
That's fine, Your Honor.
Okay. All right. So, you want sentencing pushed back to February? All right, because both of you, late February. All right, let's pick a date.
All right. So we could do any time in the morning on February 23rd.
Well, I know I'm in trial on the 20th too. I mean, all these cases were backed up because of this one. So late, the week after that would be great.
Okay. That'll push us to the first week of March. How about 9 a.m. on March 1st?
Okay.
What day of the week?
That's a Tuesday.
That would work.
Your Honor, the state's not available that week.
Okay.
Okay. Let's do March 8th at 9 a.m.
I'm sorry.
March 8th at 9 a.m.
We all have a state trial that week in March. If we could move it up a week in February would be better. Please?
Okay. So the first week of March, Mr. Frank?
I'm saying like the third week of February.
Okay. Well, we could do it February 18th at 9 a.m.
That's fine.
Is that a Tuesday?
That is a Friday.
What day, Paul?
February 18th.
January 18th, Judge.
Thank you. All right, is there anything else we need to put on the record?
No, Your Honor, thank you.
All right. Okay, thank you, counsel.
Love you, Kim.
There's a unanimous verdict in this case, not both first degree and second degree manslaughter, guilty of both of those charges. We have Joy Lim Nakran, crime and justice reporter here at Court TV, joining us, as well as still with us, Rashina Rajkumar, we have John Birdsall. Let me start with you, if I could, please, Joy. What's your reaction when this verdict was read by Judge Chu?
So to be honest with you, Judge Ashley, I was anticipating that the jury would convict Kim Potter on second-degree manslaughter because the standard is a bit lower. It's a negligence standard versus with first-degree manslaughter, a recklessness standard. And as Judge Chu acknowledged herself, attorneys on both sides presented really strong arguments, including the defense, obviously. So I really was a little bit surprised when that first reading came down of the guilty verdict for first-degree manslaughter. And I think you might be able to add a little bit more insight into this. I thought it was also noteworthy that the jury did not go with an either-or. They didn't go with first-degree and not second-degree. They went with both. So they found both recklessness and negligence here.
That's right. The reckless use of the firearm for the first degree, and that means that she was aware of the risk but disregarded. And also the second degree manslaughter, Joy, as you pointed out, and that's the culpable negligence. Not aware of the risk, but she should have been. That's the difference in those two legal definitions. John, weigh in next. What are your thoughts about guilty on both of these charges?
Well, I'm surprised too. I thought, as I said earlier, that I was leaning that it was going to be more of an acquittal. However, frankly, I'm surprised that they did both for the exact reasons that you two cited. I got to believe that at least part of this had to do with the fact that they were bumping up against Christmas and they were obviously deadlocked and they wanted to reach a verdict and go home and not like come back on Monday. And that's this major of a trial should not be held in December.
And I didn't mean to interrupt you, John, but you do wonder how much that plays a role. And I appreciate your saying they were 15 hours before they reached this verdict. They did ask Judge Chu, what do we do if we cannot reach a unanimous decision? And she sent them back to keep deliberating. Tomorrow, Christmas Eve. Did that make a difference? Rashini, I must ask you, because you have said pretty adamantly, I do not believe that first-degree manslaughter is one that she will be found guilty of, yet she has been. What are your thoughts?
Ashley, I'm shocked. We weren't on the air. My jaw dropped when I heard that on first degree. It is interesting to note the timing. If I wrote that down correctly, the judge said each of these verdicts was found. So that second degree was found at 10:30 in the morning on Tuesday, the 21st. So what they needed, and remember that question came in on Tuesday, they needed this additional time to figure out if they were going to acquit on the first degree or land where they did land. And they landed this morning on that first degree charge. So I am stunned as I read those statutes and watched what happened in court. I am surprised. Although one piece of the defense's case in chief that I always thought might come back to bite them was that they really didn't maximize the use of the video, Ashley. And when Kim Potter was saying, I'm going to kill myself, and just how regretful she was in that moment, I think if that had been maximized more, maybe the first degree would not have been found.
Well, Rashini, thank you so much for joining us live from Minnesota. I know that we're saying goodbye to you now, but Joy, John, you're going to stay with us. We want to watch the verdict one more time as read by Judge Chu.
All right, please be seated. Members of the jury, have you arrived at a verdict? Okay. Will the deputy please retrieve the verdict forms and provide it to me for review? Would Ms. Potter please rise? I'm now going to read your verdicts as it will appear in the permanent court records of Hennepin County. In the matter of State of Minnesota versus Kimberly Potter, court file number 27 CR 21 7490, we, the jury, on the charge of manslaughter in the first degree while committing a misdemeanor on or about April 11, 2021, in Hennepin County, State of Minnesota, find the defendant guilty. And the verdict was agreed to at the hour of 11:40 a.m. and signed by the jury person on 12/23/21. The verdict on count 2 is we, the jury, on the charge of manslaughter in the second degree, culpable negligence on or about April 11, 2021, in Hennepin County, State of Minnesota, find the defendant guilty. And that verdict was agreed to at 10:30 a.m. on 12/21/21. Members of the jury, is this your true and correct verdict? So say you one, and so say you all.
Yes.
Okay, you may be seated. All right, I am now going to poll the jury. Juror number 2, is this your true and correct verdict?
It is.
Juror number 6, is this your true and correct verdict?
Yes, it is.
Juror number 7, is this your true and correct verdict?
Yes, it is.
Juror number 13, is this your true and correct verdict? Oh, it's juror 11.